So, Mr. Scott, it looks like you and Ms. Krusich either are or were in a relationship,
We dated. We don't live together. Never have lived together.
but you dated.
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor.
Okay, as do you.
Yes, 30 years.
Okay. And are you in their supervisory chain of command?
Can I explain that to you, Your Honor? So, I work for the Office of the Secretary. Mrs. Gogan, she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where where the problem lies, is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, she sent these memes and information around to the office. And if you see the one that I sent you, where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I wouldn't normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now how am I supposed to work with you every day and trust when you're discriminating and doing all these acts of inappropriate behavior in the workplace? Mm-hmm. And so part of my action is I'm probably going to file a lawsuit against her. And so I need that protection for me, because per our policy, this administrative policy, she's probably going to lose her job because of that. She even the words that she uses, where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. And then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment and she's laughing her head off.
I'll be honest, there's something inherently funny about watching a grown man melt down because a woman said mean things about him on the internet. It never gets old, and a lot of you might not know this, but Chile De Castro from the YouTube channel Delete Laws has tried the exact same move on me multiple times. He's filed lawsuits against me in both federal and state court, all because I hurt his feelings online. What you're seeing on screen right now is a small snippet from one of those filings where he carefully lists the derogatory names I allegedly used. And yes, it's a long, ridiculous list. But here's the part that actually matters. None of that is illegal. Saying mean things about people on the internet, even very mean things, is protected speech under the First Amendment. And just like every other time someone tries to weaponize the courts over bruised egos, this male Karen is headed for the exact same outcome as the rest of them. Dismissal, disappointment, and a harsh reminder that the Constitution doesn't exist to protect your feelings.
So that in itself, and then I'm the senior administrative officer there. I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma SME. I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. Violations via phone, email, text, social media, electronic communication. Such behavior can also be outside of work. it specifically speaks to this in our administrative policies.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
okay, and what about Ms.
So let me finish this. Please, let me finish this.
Well,
so I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are putting photos online without the permission of
who's doing it?
Are we dating him too? It's a site it's a group that's embedded into Facebook. And currently I have with this Attorney General's to take that website down because they are putting males photos up without their permission, and they are women who are on there that are anonymous, so you don't know who it is. It could be any bandwagon person like Ms. Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. It's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very, very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website. And now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia. And she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia. It took me a long time to get that position.
Well, if that board is really so fragile that it will believe anything it reads on the internet, then maybe holding a seat on that board isn't nearly as prestigious as you think it is. And here's the other side of that coin. If you truly value that position, maybe don't date your co-workers and then act shocked when people mock your dating disasters online. Actions have consequences, reputations aren't made of glass, and the internet isn't obligated to protect you from your own bad judgment.
You know, I don't think this is the process for you to achieve what you want to achieve. Because one of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, Your Honor.
So
I
don't know how I can do something about this.
For me, it's work. I have to.
Right. But that's.
Ms. Goldman can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens,
So
Your Honor?
well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm pronouncing it. Yeah. And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is. firing or loss of pay, or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can file civil lawsuits
Oh,
against
yeah.
them for the
Yeah,
damage
That's coming. Yeah.
that's you feel
Yeah.
has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit,
Mhm.
but this process isn't meant to address that. So you're not going to get any what we would call a remedy
Oh,
out of this. I can't give you anything that will address it. So, I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear. I'm not saying that what you're having to deal with is too small for this or anything. It's just this is not the appropriate process for that.
oh, that's fair. For me, it's about exhausting all my means.
Yeah.
So
No, I
it's
understand.
not an end all for me. It's just another bullet in the process for me.
I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites, and I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there. And I'll find it. I will.
Okay.
I'm persistent, Your Honor.
Yeah, persistently stupid. Because with even the most basic level of research, you would have figured out on your own that Washington is a two-party consent state only when you're recording someone without their knowledge. What it absolutely does not mean is that both parties have to consent to being criticized online. That's not how the law works. That's not how free speech works, and pretending otherwise just makes you look even more clueless. Now, with that settled, let's move on to our next hearing, this time down in Florida, where a sovereign citizen is handed one of the best plea offers I've ever seen by a prosecutor, and then immediately trips over his own ego and stupidity, trying to ruin it.
On the morning docket, you had continued Kareem Williams from, I believe it was last week, the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete that term. Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you successfully,
If you did all those terms.
you have to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
You can do that, but you really shouldn't, because you've got a perfectly capable lawyer sitting right next to you who can answer all your questions. Plus any follow-ups your brain might eventually generate. But hey, don't let me get in the way of you and your lunch crayons. I wouldn't want to interrupt something you're clearly very committed to.
Yeah, I mean, I spoke with him shortly. I didn't really get all I really spoke over, what we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot. Due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time, and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I
I'm
can
just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the
Oh.
state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got to offer a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30, and it will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I mean,
He's
Central.
on Central Standard Time. You're on Eastern Standard Time.
So let me get this straight. You're telling me that all he had to do was subtract 1 hour from his local time and he would have at least had a chance of getting this case tossed for free. Yeah, he'll be fine. And with that, we're heading into our final hearing of the day. This one featuring a sovereign citizen who goes by House of Jennifer, which I'm pretty sure is just a dramatic medieval way of saying her name is Jennifer of the family. Jennifer. So buckle up, because this one is exactly as unhinged as it sounds.
This is case number 23-1659-92. This is LBNB Funding LLC versus Jennifer Moore. The matter is before the court, settling for a motion hearing. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please court, I am attorney Richard Bruson, and my bond number is 35222, and I am the attorney for the plaintiff.
All right. It appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right. And do I have Jennifer Moore on the Zoom?
Yes. Good morning, Your Honor.
All right. Thank you, Ms. Moore. And good morning to you, ma'am. All right. And it appears that the plaintiff is moving. That's right there. I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Ma'am, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVNV Funding when I checked my credit score. And that's how they were able to reach out to me. They were sending information to a different address. And according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting the mail and so on. So And I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed, and now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here now.
I love how sovereign citizens consistently think they can just skip a court date and nothing bad will happen, right up until wage garnishments start chewing on their paycheck. Then suddenly, court is very real and very urgent. We see this all the time. A judgment gets entered because they didn't bother to show up, and then they finally appear with some wild excuse about why they missed court. And here's the part they never seem to understand. Having a good excuse is only half the battle. Even if the court buys your reason for not showing up, you still need the other half, a meritorious defense. And spoiler alert, sovereign citizen nonsense is never that.
All right, thank you, ma'am. Mr. Rusin, your response, I do see you filed a written response, sir.
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LBNB funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so if the case continued, I can see that she filed an objection to the wage garnishment in this matter back in December of 24, and then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
This case was argued. I'm not done, madam. The case was continued to press, and so here we are now with good.
Mr. Rosen, I'm stopping you. I'm stopping you because your device was breaking up, and that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad, and so you're going in and out. You indicated the last thing that was clearly heard was that you were prepared to offer a satisfaction of judgment. You said only about $89 or so was owed.
But exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now, to file a satisfaction of judgment because it's all paid. I have no idea what the defendant is otherwise arguing about, but on that I rest.
Well, for the rest of your honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, you still, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LVNV Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LVNV Funding. Midland Funding is not involved in this, and I do not represent Midland Funding in my office. On that I rest.
In other words, if you paid Midland for that debt, congratulations. You paid the wrong person. The obligation didn't magically disappear, it just went to someone else. And that's the part people always miss. Paying the wrong party doesn't settle the debt. It just means you still owe it to the actual creditor.
All right, thank you, Council. Pam, I'm back to you this morning.
May I?
Yeah.
Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out to.
That's Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors and they stated that my account was given to Midland. And that's where my account's set. Now, however, you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this day, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is a debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature with the contract of my signature. I'm asking if there was any insurance claim. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
Like the attorney already pointed out, this is information you should have asked for a long time ago. Not now, not at the 11th hour, and definitely not just because you're suddenly mad that money is being yanked out of your paycheck to cover a debt you ignored. This isn't some legal gotcha moment. This is the consequence phase.
All right, thank you, ma'am. The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion, I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing of good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth, none of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's meritorious defense and affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion that was not in the form that is required post satisfaction of the judgment. That was a form addressing satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.
And just like every other sovereign citizen we've seen, the ending never changes. You're paying the debt whether you like it or not. That's it. That's the law. So we're wrapping this one up here, and honestly, this might be one of those videos that never gets an update. The first guy, he's just bitter and committed to staying that way. The second guy, there's still a slim chance he listens to reason, follows the pre-trial conditions, and walks away with the dismissal. And the third, Jennifer, the so-called brick house, that chapter is closed. She lost, definitively. If you enjoyed the video, hit that like button. If you didn't, smash the dislike. I welcome the hate. Either way, drop a comment, let me know what you think, and make sure you're subscribed with notifications on so you don't miss the next courtroom meltdown. I'll see you in the next one.